Right, I would like to call to order the fourth meeting of the Rhode Island Ethics Commission, properly noticed for March 4th, 2025. The first item on the agenda is the motion to approve the minutes of the open session held on February 11th, 2025. Is there a motion?
So moved.
Motion by Commissioner Rabideau. Is there a second?
Second.
Second by Commissioner Luzzi. All in favor?
Aye.
I'm gonna go around the table since I don't have my sheet. Commissioner Rabideau,
Aye.
Commissioner Strauss.
Aye.
Commissioner Susie,
Hi.
Commissioner. Yes, Commissioner Peterson, Commissioner Browner.
Wait,
Sorry,
aye.
I'm sorry, I thought I heard you vote.
Nope, you heard Commissioner Harrison.
And Commissioner Ritchie, and the chair votes aye. The next item on the agenda is the director's report.
Hey, good morning. First, I'll just note, we are live streaming and the link to the live stream is on the agenda. As always, the agenda for today's meeting is posted on our website and the meeting material, particularly all of the draft advisory opinions, are also posted onto our website and available for download or just viewing. The live stream will cover the open session. And as we move into executive session today, the live stream will end until we come back into open session. Then the meeting will recontinue. And one of the first items would be for the chair to announce any votes that were taken in executive session. We will also post any votes taken in executive session on our website later this afternoon. Moving on to the report proper regarding complaints and investigations, we have 4 complaints pending as of today. And that includes a new complaint that just came in a couple of days ago. It hasn't been initially determined yet. We couldn't prepare it in time for today's meeting and for the agenda, but it will be on the next March meeting for initial determination. And then we have the 3 other remaining complaints that have been pending. The Thorson complaint 2023-7 there. That discovery is still ongoing. I've been informed from the respondents' counsel that service of the subpoenas has been effectuated. But one of the potential deponents and witnesses for these Philadelphia depositions is out of the country right now. So that deposition is delayed until they return to the United States. I'll keep you posted on that. We have a settlement today in one of our other pending complaints. That's Michael Colasante. That'll be an executive session. And the other pending complaint, Heidi Weston Rogers, we're still in the process of completing that investigation. We're looking forward probably to a probable cause hearing either the next meeting, but most likely on April 8th. So certainly by April 8th, we'll have a probable cause hearing in that case. Regarding advisory opinions, we've had a lot come in just in the last week. So we now have 11 advisory opinions pending currently, and that includes the 4 that are on today's meeting. So aside from that, we have several others, but we're working through them and none are laid. We're able to get everyone appropriate. Interestingly, we had no APRA requests since the last meeting. It doesn't happen too often. Regarding financial disclosure, not a lot to report. As you know, the 2024 financial disclosure statements are due April 25th, 2025, which means that we are preparing to send out the blue letters, which we anticipate going out on March 17th. So in about 2 weeks, we'll mail out those blue letters that will have your PIN numbers and your person IDs and instructions for how to, for those of you that you've already found. So have you. So you won't get those letters, but the rest of us will, including myself. I will also get that letter when it comes out. And then just moving on to general office administration. Again, the next meeting is going to be March 25th. And just so you know, we're still working on some information to bring back before you to discuss the gift limits. This is aside from the common cause petition. You'll recall that we had decided we were going to kind of take a look at whether it's time to consider moving that limit up from 25 to something more. And so staff is working on some information to bring to you. We'll get that to you. That's it for the director's report. Happy to answer any questions you might have.
Commissioners, question? Thank you, Mr. Brammer. Next item on the agenda are the advisory opinions, and the first sign-up sheet is Stephen Marcel.
Morning, everyone.
Morning, Regis.
The draft for this petitioner is at tab A in your binders. Good morning, Mr. Marcello. Good morning. The petitioner is the former assistant solicitor for the town of Narragansett. As such, he was assigned to represent the town's planning board and zoning board. His initial 2-year appointment by the town council was in 2017. He was appointed twice more, in 2019 and in 2021. In January of 2023, the town council voted to replace him as the assistant solicitor and to appoint another attorney to that position. 1 month later, the petitioner prepared copies of his files and participated in transition meetings with the town manager, the town solicitor, and the attorney who was expected to be sworn in as his replacement. Later that month, the vote to appoint the newly selected assistant solicitor was tabled by the town council. Ultimately, the newly selected assistant solicitor was never sworn in and never attended any additional meetings. The petitioner's firm, though never officially voted on or reappointed, resumed the position of counsel to the zoning board and planning board and has been billing the town for those services on a month-to-month basis. No subsequent vote to reappoint the petitioner or assistant solicitor was ever taken by the town council, but the petitioner did disclose his representation of the town in his role as assistant solicitor to the Ethics Commission on his 2023 yearly financial statement. The petitioner's representation of the planning board continued until December 17th of 2024. His representation of the zoning board continued until December 19th of 2024. On June 11th of last summer, the petitioner filled in for the town's solicitor at a town council meeting because the solicitor was on vacation. On June 27th of last summer, the petitioner presided over the probate court for 1 session because both the probate judge and the solicitor were on vacation. On January 6th of this year, the town council voted to appoint a new solicitor, a new assistant solicitor, pardon me. It was not the individual who had been selected to replace the petitioner in 2023. It was someone else. The petitioner remains an attorney in private practice. Cognizant of the revolving door provisions of the code and desirous of adhering to them, he seeks guidance today regarding at what point he may represent private clients before the planning board, the zoning board, the town council, and the probate court. The code strictly prohibits a public official from representing himself or another person before a state or municipal agency of which he is a member, by which he is employed, or for which he is the appointing authority. These prohibitions continue while the public official remains in office and for a period of 1 year thereafter. However, Section 36-14-5E4 states that this prohibition shall not pertain to a matter of public record in a court of law. Looking first to the planning board and the zoning board. Petitioner last represented the planning board on December 17th of last year. He last represented the zoning board on December 19th of last year. A new assistant solicitor was not appointed until January 6th, 2025, and the petitioner remained in his position until that time. Accordingly, it is the opinion of staff that the petitioner is prohibited from representing clients before both the planning board and the zoning board prior to the expiration of 1 year following the appointment of the new assistant solicitor. So that would be January 27th of 2026. Looking to when the petitioner may next appear before the town council. Now recall that he filled in for the solicitor as counsel to the town council on June 11th of last year. In advisory opinion 2023-20, which is cited on page 3 of the draft, a former solicitor, also from Narragansett, whose main responsibilities involved advising the town council and staff on legal issues, on 1 occasion served as a substitute, this particular solicitor in 2023-20 on 1 occasion served as a substitute counsel at a zoning board meeting at the request of the assistant solicitor who could not attend. The Ethics Commission opined that he was prohibited from representing clients before the zoning board until the expiration of 1 year following his service as substitute counsel. Consistent with that advisory opinion, it is the opinion of staff that the petitioner is prohibited from representing clients before the town council in Narragansett prior to the expiration of 1 year after June 11th, 2024. Finally, as to when the petitioner may next appear before the Narragansett probate court, that would be any time at all. As previously stated, the 1 year waiting period set forth in the statute does not extend to individuals who wish to represent clients within 1 year following the date of their official severance from public service, when such representations pertain to matters of public record in a court of law. Probate courts are courts of public record. Consistent with the advisory opinions cited on page 4 of the draft, it is the opinion of staff that regardless of the petitioner having presided over the probate court in Narragansett last June 27th, he is not prohibited from representing clients within 1 year of that date. I'm happy to answer any questions or refer to the petitioner's appropriate.
Thank you, Mr. Duchess. Mr. Marcelo, do you have any comments, questions, concerns?
No, not at all. I thought my situation was rather unique in the fact that I wasn't appointed for that term. And I also filled in for different positions at different times. Narragansett's on its 6th solicitor in 8 years. So I wanted to be extra careful on what I did and when I did it to avoid any conflicts. I'd like to thank this body. As soon as I submitted something, I got a call the next day and called me within a day after that. And, I'm here within 2 weeks. I think that's very helpful to practitioners and anyone else who comes before a body, but I don't have any questions or any, I'm not contesting Lynn's report, but I did want to come before this body, again, given my unique situation with not being appointed and then filling in for different bodies at different times.
A classic case of no deed, no good deed goes unpunished.
And it was James who filled in for me 2 years ago. He had to sit out a year, so I was aware of that, but also the probate court. I was not aware.
Any commissioners have any questions? Mr. Revenue, Commissioner Revenue.
So if he served at will for the town, why doesn't the year start on his last hearing before the zoning and planning board in December? Why does it start in January when the town council voted to replace him? He was an at-will employee.
His, perhaps, but the new person was not appointed, so it would have been him that would have been called.
But he
In the
wasn't.
meantime.
Am I making sense with that? I mean, he was serving on a month-to-month basis.
I understand the question, but he was in the office. It's the office that triggers his, at least as I see it.
It is, in fact, the reason that the analysis was as though it was continuous. It's not like he was brought back. He put it on his 2023 financial statement.
So is he going to have to file in 2025? Because we're telling him the town council didn't reappoint until January 6th of 2025.
In 2025, he will file a financial statement for 2024. And then in 2026, I don't believe he served past the beginning of January. I forget what the cutoff date is.
I will say, if you stop serving all of these roles in January, you won't file.
Right.
You have to serve beyond January in order, if you just serve during January, it doesn't trigger the file.
Which makes
Yeah,
perfect
I represent
sense.
other towns, so I have to find.
Which makes perfect sense if you think about the election process, when people take office.
Right. Okay, thank you.
Any other questions, commission members? Is there a motion to approve and issue the advisory opinion as presented by staff? So moved. Commissioner Ritchie, motion.
Second.
By Commissioner Rapidu. Commissioner Susan,
Aye.
Commissioner Strauss.
Aye.
Commissioner Brown. Aye. Commissioner Harrison,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie, and the chair votes aye. Thank you, Mr. Marcelo.
Thank you, everybody.
Thanks for coming in.
Thank
Nice to meet you. Thank you.
The next item on the sign-up sheet, I believe, is Patterson. Is that correct?
Draft is at tab B in your binders. Welcome, Mr. Patterson. He is here with his attorney, John Buck, KUPA.
Welcome.
Petitioner is a member of the Exeter Town Council. He seeks an advisory opinion regarding whether he qualifies for a hardship exception to the code's prohibition against representing himself, whether individually or through an authorized representative. First, before the town planner, over whom the town council has appointing authority, and then before the town council, for the purpose of making applications related to his intended sale of property that he owns. Petitioner owns a 50-acre farm located in Exeter that he purchased in 1996. He and his family have lived on that farm continuously since the year 2000 in a home that the petitioner built. Christmas trees are the farm's major crop production. Other crops include nursery stock, annuals, and perennials. A retail building was built in 2005 for plants, gifts, and nursery sales. Petitioner states that his property is currently zoned as residential with a special use permit for retail sales. He further states that due to the COVID-19 pandemic and inflation, it is no longer feasible for him to continue the operation of his retail building. The petitioner would like to subdivide a 4-acre lot from the farm on the portion of his property where his retail building is located. To accomplish this, he must make 2 successful applications for administrative subdivisions. Administrative subdivisions are performed by the town planner, again, who is appointed by majority vote of the town council. The first application would seek the approval of a land swap between the petitioner and the owner of a neighboring parcel in order for the petitioner to obtain the road frontage required to subdivide the proposed lot. The second application would be for the actual creation of the 4-acre lot. If these 2 steps are successful, the petitioner would then like to apply to the town council for a zone change for the newly created lot from residential with a special use permit for retail sales to commercial. The petitioner would then like to sell the new 4-acre lot and the retail building that is located on it, which would leave him with a 46-acre parcel. The petitioner states that he plans to invest the proceeds from the sale of the new lot and the commercial building in the farm. He would like to first pay off the mortgage on the retail building and his residence, and then create a rural residential compound for his family, consistent with the provisions of the town's subdivision ordinances, which allow for housing but do require the preservation of farmland and open space properties. The petitioner states that 50% of a parcel intended for subdivision must be deeded as open space in perpetuity and used only for agricultural and recreational purposes. 1 lot is allowed for every 10 acres of the remaining 50% of the parcel. The petitioner is prepared to deed 23 acres of his remaining 46-acre parcel as open space, which he would continue to use to produce Christmas trees and nursery stock in conformance with municipal law. He seeks to create from the 23 remaining acres a 4-lot subdivision that would include his current dwelling and 3 new lots on which homes will be built by each of his 3 adult children who, according to the petitioner, are finding it difficult, if not impossible, to afford housing in Rhode Island. Following the sale of the newly created 4-acre lot and the payoff of the mortgages, the petitioner intends to use the remaining funds to contribute to the expenses of engineering, surveying, and legal fees associated with the proposed subdivision, which he estimates will be between $120,000 and $140,000. He adds that there will be additional expenses of constructing a private roadway. The petitioner emphasizes that the purpose of this project is to enable his 3 children who grew up on the farm to be able to have homes they can afford and to allow his property to maintain its farm status for generations to come. Looking now to the Code of Ethics, this analysis involves one statute, section 36-14-5E, and its defining regulation, which is 1.1.4. A public official may not represent himself or authorize another person to appear on his behalf before a state or municipal agency of which he is a member, by which he is employed, or for which he is the appointing authority. While many conflicts can be avoided under the code by recusing from participation in certain matters, such recusal is insufficient to avoid this statute's prohibitions. Absent an express finding by the Ethics Commission that a hardship exists, these prohibitions continue while the public official remains in office and for a period of 1 year thereafter. Upon receipt of a hardship exception, the public official must advise the state or municipal agency in writing of the existence and nature of his interest in the matter, recuse from voting on or otherwise participating in the agency's consideration of the matter, and follow any other recommendations that the Ethics Commission may make in order to avoid any appearance of impropriety in the matter. The petitioner's proposed conduct falls squarely within the code's prohibition against representing himself before the town council, of which he is a member, and before the town planner, over whom the town council has appointing authority. Consideration must now be given as to whether the unique circumstances represented by the petitioner justify a finding of hardship to permit him to engage in the proposed conduct. Questions of hardship are reviewed on a case-by-case basis, and the Ethics Commission has in the past considered some of the following factors in cases involving real property. Whether the subject property involved the official's principal residence or principal place of business. Reminds me, I hope I fed the dog. Second,
It's a good one.
whether the official's interest in the property was pre-existing to his public office or recently acquired, whether the relief sought involved a new commercial venture or an existing business, and whether the matter involved a significant economic impact. The Ethics Commission may consider other factors, and no single factor is determinative. Pages 3 and 4 of the draft contain both advisory opinions in which hardship exceptions were granted and advisory opinions in which they were not. Looking first to the opinions in which a hardship exception was granted. Advisory opinion 2020-20, a member of the South Kingstown Planning Board was allowed to represent himself before his own board in order to seek to subdivide property that he had owned for 7 years before joining the planning board and on which a residence was located that his daughter occupied. That petitioner wanted to make a second lot, construct a second residence. The daughter would remain in her residence. Another child of the petitioner would live in the second residence. Advisory opinion 2017-6, a member of the Hopkinton Planning Board was allowed to represent himself before his own board to establish a family residential compound on property that had been in the family for years. That petitioner wished to provide land to his children to build their own homes. And advisory opinion 2012-16, a member of the Foster Town Council was allowed to represent himself before the Foster Zoning Board and the Planning Board in pursuit of establishing a residential compound on his personal property. His ownership predated the appointment to the town council. He was seeking to subdivide the property in order to provide land to his children to build their own homes. In contrast, the Ethics Commission has declined to grant a hardship exception for matters involving new commercial ventures. In advisory opinion 2003-49, the Ethics Commission declined granting a hardship exception to the assistant solicitor for the town of Lincoln, who wanted to represent himself before the town council, the zoning board, and the planning board relative to the development of 2 parcels of real estate that he owned in Lincoln, because first, his ownership of the lots did not predate his appointment as solicitor, but also it was uncertain as to whether either lot would be used as the petitioner's primary residence or simply resold in a commercial transaction after the development. In advisory opinion 2000-41, the Ethics Commission declined granting a hardship exception to a member of the Exeter Zoning Board who sought to generate additional income by entering into a contract to locate a cellular communications tower on his residential property because the proposed commercial venture served only to generate additional income for him. And finally, in advisory opinion 97-146, the Ethics Commission declined granting a hardship exception to a member of the North Kingstown Zoning Board who wished to appear before that board to seek approval for certain variances relating to a residential subdivision in town for which he was the developer. There are some similarities between the intention of the instant petitioner, who after selling the newly created lot in a commercial transaction, wishes to ultimately create a residential compound for his family on his property, and the intention of the petitioners in the advisory opinions where hardship exceptions were granted, in that the ownership interest of Mr. Patterson's property does predate his election to the town council. However, none of the proposed family compounds sought to be established by those other petitioners relied on the creation and sale of a new commercial lot. This fact distinguishes Mr. Patterson from those petitioners to whom hardship exceptions were previously granted, and aligns him more closely to the petitioners in the advisory opinions where hardship exceptions were denied because their plans all involved a new commercial venture. Here, the petitioner's request to seek zoning relief and approval from both the town planner and the town council are directly tied to the petitioner's desire to create and sell a 4-acre commercial lot, which is not a necessary element of creating the 4-lot subdivision as described as his vision for the family compound. The petitioner's plan to sell the newly created 4-acre lot would be a commercial transaction, that he represents an intent to use some of the proceeds from that sale to fund the creation of a rural residential compound for his family does not erase or transform the commercial nature of the initial project funding sale. Requests by public officials to appear before their own agencies or before agencies over which they have appointing authority are routinely denied under circumstances in which a new commercial transaction is involved or anticipated. Accordingly, based on the petitioner's representations, the applicable preservation provisions of the Code of Ethics, and consistent with prior advisory opinions issued, it is the opinion of staff that the circumstances here do not justify the granting of a hardship exception, and that therefore the petitioner may not appear before the planner or the town council, either individually or through legal counsel, for the purposes described, prior to the expiration of 1 year following his official severance from the town council. I'm happy to answer any questions or defer to Mr. Patterson or his counsel as appropriate.
Thank you. Mr. Kuba, Mr. Patterson, you've had an opportunity to read this advisory opinion before today.
Yes, we have.
I'd like to turn it to you then to make any comments, questions, concerns you have. And we allow both attorneys and the party to express themselves here, but I'll turn to you first, Mr. Kuba.
Thank you. This is a situation, as Lynn explained, where he owned this property for a substantial period of time before he became elected. Circumstances changed. In this particular case, the farming of these properties and the political restore type situation had faded. Again, with COVID, it's never been known. There are phases to this project that I'm hopeful the board will see as I do, which is ministerial. And that is where we have the administrative subdivisions. The state legislature in the past and continues strongly now to make it, I'm going to say simpler, but to make it a more narrow, focused approach to permitting these types of things. And it has really become only a ministerial act of planner, where there is an administrative subdivision. And we'll go, the first thing that you would like to have done, which is the land swap. It is a very simple thing. It has been agreed to between one property owner and Mr. Patterson, the other property. It actually, and I don't think Glenn knows this, it actually solves a small problem that the other property owner has, in that he built inside the zoning setbacks with his substantially large building that fronts on Route 2 So he's gonna get enough land so he can now meet those setbacks. Mr. Patterson's getting frontage land, which for the most part is freshwater well. The act of the planner, if Mr. Patterson's surveyor shows how he meets all of the criteria, is ministerial. He has to sign off on it, it has to be recorded. Now, I do understand that Mr. Patterson was probably involved in the appointment of this individual. Again, it's not an act whereby the planner has to have a choice, if you will. You meet criteria A, B, C, and D, you are approved. So that also applies to cutting a lot off of the frontage, the commercial building. It's an administrative subdivision, it's an administrative process, mostly carried out by a land surveyor. Surveyor says, here's the setbacks, meet that, and they meet all of the criteria without seeking or needing any variances or waivers from the planning commission. And the planner, it does not have a opportunity to say no, unless there is some deviation from the administrative subdivision process. Doesn't go before planning commission. It's all done in. Then that brings us to the rezoning and the further subdivision. By the time the first two get done, Mr. Patterson will no longer be a member of the Exeter Town Council. It will be more than a year. So we would at least implore you to find a hardship where it is really an administrative task, which is routinely done and not a planning commission situation. And it is an obligation of the planner to follow the law. And the law says if you meet the criteria, it's just a simple decision on behalf of the planner, and is a recording process at the town clerk's office. Those two we would like to see hardships on. The other ones are a little more involved. And Lynn's made it fair assessment of the situation, and we are willing to accept that, knowing that Mr. Patterson will not be a member of town council soon. So that's what we'd like from you. You're fine.
Before I turn to the other commissioner, I just want to ask, he won't be a member soon?
Yeah, because this is interfering with what he has to do, so he's going to resign at some point, probably after the budget's done.
Ms. Radicious, do you have anything to add based on what you've heard at the moment?
I do. Initially, I did not divorce the administrative applications, subdivision applications from the ultimate goal to purchase because they were described to me as so closely aligned and attached to the intent to have the zoning change. If Mr. Patterson were to just simply sell the parcel, he would not otherwise need to go before the town council, except to change the zoning. And the three were described to me as kind of all together. So this is new information. At the risk of being the skunk at the picnic, I will remind everyone of the petitioner's obligation to seek a hardship or to require a hardship if he chooses to go before his former agency within before the expiration of 1 year from his departure therefrom. It may make a difference in seeking a hardship that he's off, but by way of full disclosure.
Commissioners, I'll turn it to you. Mr. Rapid,
Yeah.
somehow I knew you'd be coming along.
I know. The petitioner has a residential lot with a special use permit for a retail building.
Correct.
So that carries only with him. If you were to create the new lot and sell the lot without any zone change, it's a residential lot with a building. would that affect your staff's opinion?
Only in that if Mr. Patterson were not seeking a zone change for the 4 acres he intends to subdivide, he would not need to go before the town council.
So he basically listening to Mr. Cooper. He can seek the land swap and he can seek an administrative subdivision for a 4 acre parcel that has a building on it. Because the building is not going to be a commercial building as soon as he changes title. That special use permit only goes with Mr. Patterson. Am I correct, Mr. Cooper? Special use, that's why you have to do the zone change to sell the building as a commercial building.
Yeah, but the special use permit will run with the land.
Yes.
So if I buy the building from Mr. Patterson, I get a special use permit for that?
You do. Unfortunately,
Okay, well then,
but thank you.
Yeah.
that was the way I was trying to get to a point where you could do that, because now it's still a commercial transaction.
If, after the rezone, it will be. But not,
You're telling me the special use permit carries when I buy that land with the commercial building?
After the reason. What do you say? It's up to
what
the
I'm
reason.
saying is that right now, there is a special use
On a residential lot.
which permits the commercial use, which is basically a farm stand and a country store.
Understandable.
What he's seeking, again, is an administrative subdivision on that farm stand,
Mhm.
which will create an individual lot by moving lot lines, which is a ministerial act, as I'm sure you know, of the plan.
Correct.
As long as you meet everything. Once that's done, to go forward with a reason, to go forward with a,
But stop there for a minute. Once that's done, does that new lot have a special use permit for that building? Because you've created a brand new lot. It goes with
I would-
Mr. Patterson's original lot.
it would go with the entire parcel still, but now it's been reduced.
Do you see what I'm trying to get at, though?
I do, I do. And the reason we're asking for these hardships, they are ministerial acts of the plan. They're not something where he has to rule on terms of a beat it or you don't. As far as the zone change, as far as the further subdivision, all of which will appear before either the council or the planning. Those are acts that we have to have Mr. Patterson end his political career for at least a year before he's able to go forward with those. That we understand.
I think the staff report says that the rural residential compound can be done with hardship exemption. It's the commercial transaction that can't be done with hardship exemption. Right? Am I interpreting that right?
That's correct.
Yeah, so it's all, Mr. Patterson, it's all about this commercial building.
But, excuse me, Commissioner
It's
Rabbit,
about this commercial building.
but Commissioner Rabbit, as I understand it, they're not selling that lot yet. Right? That's going to go for sale later on. He already has a commercial use. He's just reducing the scope of
But he wants to sell the lot to fund the residential
it
compound.
eventually.
And he needs to go before the board, the commission to do that. That's the problem, right?
To get,
I guess, are you changing your request for what opinion do you, I'm confused now because you said we understand the limit, but we'd like just the,
Originally, my request was, can I represent myself? And after discussing it with her, found out couldn't, so. I know I have to recuse myself. So that was the simple question. I can't represent myself. But we're in- So
my question is, are you changing what you said I guess I'm lost now about what we're going to be talking about. Are we talking about this opinion? Or are we changing it to, I think during Cooper, you mentioned that we understand that the later parts can't happen, but we want you to find hardship for the ministerial action. So that's not what this opinion addresses.
No, I know that it addresses it to some extent, but you have to have a working out administrative subdivision procedures. Yes, in order to come up with the argument that I'm making.
So about that,
Yeah.
you said that it's criterion A, B, C, and D. There is no judgment call about whether you meet criterion A, B, C, or D.
No, you
There's
can make
no
it or you
way.
don't.
What is it? What is the criterion?
You're asking me, I'm not, off the top of my head, I do practice in about 15 municipalities, they're all different, so.
What's a good example of what? Because I don't, like you said, I
Needs
don't have
the-
working knowledge.
So an administrative subdivision, let's talk about the land swap.
Mhm.
Okay. When you do that, you might have to have a survey, it has to be a class A survey, class 1 survey. Has to show all the boundaries.
Okay,
If you're not putting anything in it, it's purely a land swap, which this is, that's really all you have to show. You're getting some, I'm getting some. The land that I'm getting is merged into my lot. The land that we are giving is merged into the other. So they don't become independent lots,
Mhm.
they're merged. And that's really all the criteria that would take. And that's all there is. It's a class 1 survey. It's been done by, American Engineer.
No,
I'm sorry, Christopher Pollard, professional lands in there. And, that, those two things meet. You're not creating a lot that doesn't conform because it's being merged with the primary.
who decides the need?
It meets because there's the elimination of a lot line so that it merges.
The only thing,
Primary.
I beg your pardon, the only thing I'd like to point out is the administrative applications are not relevant to the anticipated subdivision to create the family compound. The administrative applications are strictly to create a 4-acre lot to sell, which is not going to be used to develop the family compound. They're separate.
I want to ask my commissioners a question because it seems to me, and Mr. Cooper, you as well, it sounds to me, first of all, as if this is not an utterly time pressing matter where if we don't make a decision today, for example, he's going to lose everything.
Correct.
And it sounds to me as if you are in fact amending your request to reduce it to the first couple steps and not the later steps.
That is correct.
Then I'm not clear why we would not want to give you the opportunities to resubmit a limited request and allow staff to do their job on that request, which might be a different bit of a job than on this one, which was broad, and come back before us. We have upcoming meetings regularly. I don't want to take that step if it's not acceptable to you, but I think we're all a little uncertain about how we would approach even the problem you're
Okay.
putting before
But
us.
we can focus it down to the two main items that we would like to move before.
Can add to that though, please. The whole, the concern of the staff. is the commercial aspect. Yeah, Mr. Decius,
Yes.
and I would like that. Chairman to also be addressed by council. I have some concerns about that in my old days as assistant solicitor in North Providence. So, see if you can bring that to a discussion point as well.
I mean, the commercial aspect of this really doesn't get triggered until it's rezoned, in my eyes.
And again, I have some concerns about this. I don't think it's as much of a deterrent as staff thinks it is, but that's neither here nor there.
Very good. So we will do that. And then we have,
We're not quite there yet.
much more.
We're not quite there yet. Is there a motion to allow, I'll put it this way, is there a motion to allow Mr. Patterson to withdraw his present request for an advisory opinion with the understanding that he will be resubmitting that request?
So moved.
Motion by Commissioner Susie, seconded by Commissioner Rabidou. Commissioner Susie,
Aye.
Commissioner Strauss. Commissioner Browner.
Aye.
Commissioner Harrison,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie,
Aye.
and the chair votes aye. Thank you for the presentation.
Thank you. Be able to use it very.
Oh.
Next item on this sign-in sheet is Timothy McNamara.
Welcome, Mr. McNamara. The draft for this petitioner is at tab C in your binder. Petitioner is a member of the Barrington School Committee. He was elected to that position last November. For the past 14 years, he has been very involved in the town's youth lacrosse league, both as a coach and as the boys program director. The former president of that league is now the head coach for the Barrington High School boys varsity lacrosse team. Coach usually has 2 to 3 assistant coaches to help him out during the lacrosse season, but this year has no one. The petitioner would like to step up and become the head coach's assistant, provided that the code of ethics does not prohibit him from doing so. Importantly, although the head coach is compensated for his services, there is no stipend or remuneration associated with the position of assistant coach for the boys varsity lacrosse team. The school committee does not advertise for the assistant coach position, nor does the school committee participate in the selection of candidates or the interview or the final selection of an assistant coach. The head coach finds people who are capable and willing to volunteer. The season runs from mid-March to May. Practices are weekdays and one weekend day from 4 p.m. to 5:30 p.m. unless it's a game day, and then there is no practice. Games are usually twice a week on Mondays and Thursdays. Now, the school committee usually meets once or twice each month on a Thursday at 7 p.m. Petitioner has already told the head coach that in the event that he becomes an assistant coach and there is a conflict, he will be attending the school committee meeting, which may require him to miss a game. Petitioner has also made clear to the Ethics Commission staff that should any matters related to the boys varsity lacrosse team come before the school committee during his term, he would recuse or seek additional guidance from the Ethics Commission. Looking to the code, the municipal official revolving door regulation, which is 1.5.4, states that a municipal elected official or school committee member, elected or appointed, is prohibited from seeking or accepting employment in the same municipality in which the public official serves, including services as an independent contractor or consultant while serving in an office and for a period of 1 year after leaving office. Additionally, pursuant to regulation 1.5.1, no elected or appointed official may accept employment or election that requires approval by the body of which he is or was a member to any position which carries with it financial benefit or remuneration until the expiration of 1 year after the termination of that person's membership on the body. Notably, the receipt of compensation is a necessary element in the application of both regulations. The Ethics Commission has previously permitted public officials to accept certain positions within their municipality, provided that they agree to waive receipt of financial benefit or remuneration and serve in a volunteer capacity. There are some examples cited on pages 2 and 3 of the draft. This is a non-issue here because there is no stipend or financial benefit associated with the position of assistant coach to the boys varsity lacrosse team, nor does the school committee advertise for the position or take part in the selection of anyone to do that. Accordingly, it is the position of staff that the Code of Ethics does not prohibit Mr. McNamara from simultaneously serving as a member of the school committee and as a volunteer assistant coach for the boys varsity lacrosse team. Now, he may or may not be required to recuse from certain school committee discussions and voting, depending on the nature of the matter that is pending before his agency. He is indeed encouraged to seek further guidance from the Ethics Commission if and when a matter involving the boys varsity lacrosse team at the high school is before the school committee. I'm happy to answer any questions or defer to the petitioner.
To Mr. Magnin. I'm sorry. Mr. McNamara first, too many names today. You've had a chance to talk with, Ms. Rodriguez, and you've seen the advisory opinion.
Yeah.
Do you have any questions or concerns? Commission members, questions or concerns? Is there a motion to approve and issue the advisory opinion as presented by the staff? Moved by Commissioner, do this right, sir, or later? Harrison, it's right there in front of me. Second? Second by Commissioner Browner. Commissioner Susie,
Aye.
Commissioner Strauss. Aye. Commissioner Browner,
Aye.
Commissioner Harrison,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye.
Thank you so much.
Hope you have a good season.
Appreciate it.
Thank you for coming.
Thank you so
Pleasure.
Appreciate it.
Last advisory opinion today is Elizabeth Kinder.
This draft advisory opinion is in the top G in your binders. Good morning, Commissioners.
Good morning.
Ms. Kinder unfortunately cannot be present today, but she has consented to present in the draft in her absence, and she's aware that if you have any questions for her, you may postpone the decision until a later date. I spoke to the petitioner yesterday, and she noted one correction. On page 2, the middle paragraph, third sentence down states, the petitioner states that the nursery has been a family business for 150 years. She noted that it's 130 years rather than 150. So
After the opinion.
Wow. The petitioner represents that she was offered an appointment to the East Providence Tree Commission. However, she hasn't been sworn in yet. According to the Tree Commission's chairperson, the Tree Commission is comprised of 5 members, regular members, and 3 ex officio members who currently include a member of the planning department, a member of the city council, and the tree warden. The Tree Commission meets the minimum quarterly, but they can meet more often if that's needed. Pursuant to the city ordinance, the duties of the Tree Commission include the protection, maintenance, removal, and planting of trees on public property, and the hearing of appeals of decision of the city forester. The chairperson noted that the majority of the duties of the Tree Commission are to identify potential location for tree planting, and then identifying the species of trees that can be planted in those locations. The petitioner represents that the tree planting projects that will cost the city more than $2,500 normally go out to bid, and the city chooses at least 3 bids. The petitioner further represents that the Tree Commission is advisory in nature only, has no final decision-making authority relative to tree-related projects, and does not participate in the bid specifications or the selection of the companies to whom the bids are awarded. The Tree Commission's chairperson explained that when tree planting projects do not go out to bid, then the city goes to a nursery and purchases directly from there the trees or plants that they would like. The chairperson normally would go personally to that nursery, tag the plants that the city would purchase. The chairperson explained that funding for various tree planting projects comes from different sources, including federal or state grants and the city budget. The petitioner represents that in her private capacity, she is the managing director of Samuel Kinder and Brother, Inc. That's a nursery and landscaping business located in Bristol, Rhode Island. The petitioner explains that the business sells the trees it grows and performs tree planting. As I noted, the petitioner states that the nursery has been in her family for 130 years. The petitioner further states that she became the managing director in 2021 after the passing of her father, and that since that time, the nursery has not bid on any projects in East Providence. She's not aware whether or not prior to 2021, the nursery had done business with East Providence. She represents that she would like to be able to bid on city projects to supply and plant trees if and when such projects become available. The petitioner further represents that she will recuse from participating in tree commission's discussions, decision-making, and or recommendations on matters in which she expects that the nursery will bid and or be financially impacted. Finally, the petitioner states that she does not expect that she will have to recuse on a regular basis because the nursery specializes in large mature trees, which she does not expect that the city of East Providence would need on a regular basis. To the best of her knowledge, the city utilizes a specific nursery from which they buy their plants and trees each year. Given this set of facts, the petitioner seeks guidance from the Ethics Commission regarding whether the Code of Ethics prohibits her from bidding on tree-related city projects while serving as a member of the Tree Commission. The Code of Ethics, I've reviewed several provisions of the code, 5A, 7A, 5D, and 5H. Section 5H prohibits a person subject to the Code of Ethics or any person within her family or business associate of the person or any business entity in which the person or any person within her family or business associate has 10% or greater equity interest or $5,000 or greater from entering in any contracts with any state or municipal agency unless the contract has been awarded through an open and public bidding process, including prior public notice and subsequent public disclosure of all proposals considered and contracts awarded. Additionally, even if we have that public and open bidding process, the public official will still need to recuse from participating in the planning and development of any requests for proposals. The Ethics Commission has previously determined that the public officials who participated in the bid development process for a public entity place themselves, so their family members or business associate in an advantage. By doing so, they contravene the open and public process required under the code. Here, it is the opinion of the staff that the petitioner may bid and enter into contracts on behalf of the nursery with the city to provide trees or tree planting services only if it is pursuant to open and public bidding. Additionally, the petitioner cannot have otherwise participated or influenced the bid development process. That would include, but is not limited to, identifying the locations and the species to be planted in those locations and or participating in the bid selection or award of the project. Finally, the petitioner may not allow her private business interest to interfere with her independence of judgment as to her public duties and may not use any non-public or confidential information she's received by reason of her public duties to obtain financial gain for herself or the nursery. Given that this advisory opinion is general and somewhat hypothetical in nature, the Ethics Commission, we are unable to provide the petitioner with specific guidance. That's why she is advised to seek further guidance from the commission if she would wish to bid on any projects from the city. The petitioner is encouraged to, and this general advisory opinion may not apply to a specific project and allow her to bid. Therefore, she is advised to seek further guidance. I'm happy to answer any questions you may have at this time.
Commissioners? Questions? Is there a motion to approve and issue the advisory opinion as presented by the staff?
So
By Commissioner Susie, a second. Second by Commissioner Brown. Commissioner Susie,
aye.
Commissioner Strauss.
Aye.
Commissioner Browner. Aye. Commissioner Harrison,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie. And the chair votes aye.
Thank you.
That concludes the advisory committee. We have next on the agenda, the continuing discussion of potential rulemaking.
Hi, so as you know, this item is on the agenda kind of as a placeholder for every meeting going forward until you've decided how you want to handle this. This stemmed from Common Cause's petition for rulemaking that you heard about at the prior meeting. And I just want to tell you a little bit about where we are and about kind of what the process will look like going forward, but we don't really have a whole lot to discuss today. So as you know, Common Cause filed a petition for rulemaking, and all that's left of that is there were three different moving parts to it before. There's only one part, and that is the issue of they're asking you to consider amending the gift rule to expand upon gifts that apply to the gift rule, rather than just be interested persons, which are people who have a financial interest in decisions that the public official makes. They want to keep that. And then they want to also say, and also registered lobbyists should just automatically apply to that. And we're not quite sure whether their proposal is going to be to apply to everyone subject to the code of ethics. Registered lobbyists have to stick within those $25 limits, or maybe they're going to just keep it to the people that they're trying to influence. Like a legislative lobbyist it should apply to gifts they want to give to the legislature. We'll find that out because Common Cause is preparing some draft language for you to consider. It's not ready today, but it'll probably be ready either at the next meeting or the one after that. And when that's ready, Common Cause and John Marion will present you with draft language for your consideration. And until we get that, there's really nothing to do. But I'll just tell you a little bit about how the process will look and what the rulemaking process is. For you to adopt rules or regulations or provisions of the Code of Ethics, we're required to follow the Administrative Procedures Act, which is a set of rules that all administrative agencies must follow to engage in rulemaking. And it's not that difficult, but there are a few steps along the way. The good news is, until you settle on a particular proposal, we don't really have many steps that we have to follow. You can just continue to meet and discuss and talk about things. So what's going to happen for the next few meetings is we don't have to do a lot technically under the Administrative Procedures Act for now, except Common Cause will give you the proposed language. You'll take a look at it. You might say, it looks pretty good, but we don't like this part of it. We don't like the other part. You could direct me to go back. At that point, you could direct me to make the amendments that you want to see at the following meeting. Let's change this. Let's add this. It doesn't mean you're going to adopt it. It just means let's see what we can put together. It may be that finally at a meeting, you take a look at what the proposal is and a majority of you think, I think we've done it. This is not going to work. Let's just stop the process right now. And that'll stop it. And we'll never go into rulemaking, and that will be the end. However, you might say, okay, there's something here. We would like to get some public comment. We'd like to move the process forward. And at that point, we can start to go into some formal rulemaking. And what that will look like is, if that's what you decide to do, then the staff will undertake kind of a regulatory analysis where we'll look at the rule and decide, measure the costs and benefits and how much it might cost the state. These are things you have to do when you're enacting regulations. And then we'll file a formal notice of proposed rulemaking. File that on our website, we'll file it with the Secretary of State's office, and that will trigger a few things to happen. Along with that, we will solicit public comment, a written comment. We'll send emails to all the people who have ever told us that they're interested in rulemaking that the Ethics Commission does. We'll probably go further than that. We'll probably send notice to all the cities and towns and to the General Assembly and to the governor's office asking if they would like to weigh in with written comment on that. And then we will notice the public comment period. It has to be at least 30 days. And during that public comment period, we'll also notice a public meeting where people can come to the Ethics Commission and testify either in favor of it or against it, or say what they want to say. And that process, if you're familiar with committee work in the General Assembly, it looks a lot like that. So, except you'll be sitting as the committee, people will come, we'll probably get a stenographer at that point and take a stenographic record of all the comments. Sometimes we have one person show up and give comments, and sometimes we have 15. You just never really know what will happen. So you'll take the public comment, you'll consider it, and then we'll also publish a rulemaking record, which on our website, which has everything that you've considered, will be on our website so the public can see what you've been looking at. And then ultimately, the commission will decide whether you want to vote to adopt the regulation or not. You can decide not to vote and just stop the process, and it's over. If you decide to take a vote, then someone would make a motion probably to adopt the regulation, or to amend it further. But to adopt it, you'll need a 2/3 vote. Unlike everything else that you do, that a majority usually suffices. So if there are 9 members of the commission, which there currently are, you'll need 6 ayes to adopt the regulation.
2/3 of the present members, I mean, the members present at the meeting.
No, 2/3 of however members there are at the time. So if there's 1 vacancy, or say there are 2 vacancies, so then there are only 7 members of the commission. This is how I read it. But, this is something we'll go over with legal
Well, that
counsel.
would be consistent with the advisory opinions.
Yeah. So chances are, if it happens in the next year, we're probably going to have 9 members. So it's going to be 6. We'll need a majority of 6. If we have 8 or 9 members, then we still need 6 people, right? To get 2/3. So if that passes, then I'll file the final rule with the Secretary of State's office, and the regulation would become effective either 20 days after I file it, or you can set a date farther out. So if you wanted to make it January 1st, 2026 or something like that, you can do that. And that's the rulemaking process. The nuts and bolts and that will take care of that part. We'll just tee it up for you to do the heavy lifting on the policy decisions. So that is to say that I'm anticipating at the next meeting, we'll probably have, a draft proposal from Common Cause. And I'm in touch with John Marion of Common Cause, and he understands the process. He assures me he's got some good ideas to put something together for your consideration. Do you have any questions about the proposals or what we're doing or the procedures or anything?
I have one thing I think I would add for, while we look at the draft language, it would be very helpful to see the other state versions of this that we mentioned.
Yeah.
And so whether that comes from Common Cause or it comes from staff, that would be very helpful, because we'd like to see how that compares.
So, yes, absolutely. That's part of it. They've already provided some background, and they may have more that they want to provide to you. I'll also undertake an analysis too. But again, it won't be apples to apples, as long as you keep that in mind, because some states that do designate lobbyists, maybe it's just the legislative ethics, and it doesn't apply to the executive branch and things like that. But I'll note research, and I'll try to give you kind of a broad swath of what, especially focusing on New England and then nationwide.
So my only comments for the non-lawyers, which is that the process that Jason just laid out is expressly set forth in statute. So it's not something we make up, something we have to follow. To be clear, that procedure is step by step by step. So just be aware of that. We can't waive it. We can't work around it. We're stuck with it.
There are a couple additional steps that are, I don't want to get too far into it, but in past years, some steps have been added that where where the Department of Administration and the executive branch gets a little bit of veto power over the rulemaking process in terms of reviewing it. And our position at the Ethics Commission has always been that you don't get to veto what the Ethics Commission wants to do from the governor's office or from the executive branch. And it's kind of a tiptoeing tap dance. Nobody really wants to have that kind of turf war, and we never. So I don't anticipate we'll have it going forward, but it's a delicate discussion. So we'll get to that.
If it goes notice and comment, do we have to respond to each comment publicly?
So ultimately,
Or will we respond to each comment, or groups of comments, categories of comments?
ultimately, when we do the final rule, we are supposed to note why we didn't choose certain alternatives. So if there were other alternatives proposed, and the thing is, the staff will help draft those for your approval in terms of, why didn't we go this direction? Why didn't we go that direction? Why did we choose this? So yes.
Yeah, okay.
Have one question. Public comment. Going to advertise as required. The making process and so on and so forth. What is the form of advertising? What's the form?
In the old days, we had to run an article in a newspaper of statewide circulation, which always meant the Providence Journal, back then. That's changed since, and we don't have to, thankfully, because this is very expensive. I mean, this is part of the reason why the newspaper industry is not doing so well these days. But so we don't have to do that any longer, but in lieu of that, we advertise on the Secretary of State's website, and so the Secretary of State has a process to kind of push that information out to interested people, and where people can find that information as kind of a clearinghouse of rulemaking. We also have to advertise it on our own website, and we have to send notice to anyone who has previously, within a reasonable amount of time, let us know that they're interested in our rulemaking process.
So the public.
We maintain a list.
Yeah, so the public in general, unlike the old days, I call this as being involved in notification issues. They really won't know. Basically, it's sort of a constricted group, so to speak. Kind of really sports where they have took it on themselves to spend the money to seek opinions from the public in such situations.
I can't speak for them as to whether they've spent money. My guess is,
Well, whatever,
but they've got a membership list, they've got members, and when they need to rally the troops, Common Cause has shown themselves able to get their members involved and to form coalitions with other government groups like the League of Women Voters and the ACLU. And
so that leads to my next question. That is, if there is a substantial turnout, we would then have to provide a timeline for people to appear before us, make their. We'd have to somehow engage. So that's not going to be done in a normal setting this morning. So you anticipate how that the range and the decisions made.
I do. Traditionally, we have always done public comment in this room. And we've done a lot. We haven't done a lot recently, but the Ethics Commission has done a lot of rulemaking over the last 25 years since I've been involved with the Ethics Commission. And even on the most publicly involved provisions of regulations, this room has always been sufficient to handle.
I meant time-wise. I understand the room is sufficient. I'm talking about in terms of allowing everyone to speak their mind and give us an opportunity, if we choose to engage, I think we're talking the hours and hours.
I don't think it will be. I think normally the commission sets a reasonable expectation, please try to limit your comments to 5 or 10 minutes, that type of thing. And it usually, even the most long-winded of, even, back when, I'm not gonna name names, but we've had some long-winded people up before the commission, they usually wind down after 10 minutes or so. So, it has worked out. I think we'll be able to fit everyone in. Sometimes you get surprised and honestly, it'll probably be less people than you think that show up to actually testify. We'll get a lot of written comment. We'll get emails. We have a designated email account that's just for comments on regulations that we'll advertise, and we'll get a lot of email in through that. We'll distribute all of that to you.
My only concern is common cause. If they're going to be satisfied with the arrangements for public input.
Oh, I guarantee it.
Yeah, he's here.
Oh, is that?
They've been satisfied so far, and they know how to complain if they.
And I'd just like to make one response, sort of, Commissioner Ritchie, which is that we cannot rely on or use notice that may be given out by Common Cause. It's our obligation, and it's not Common Cause's rule. Once we make our decisions, it's our rule to consider. They may be providing us information, they may be the,
Absolutely.
generating source, but once it's here, it's ours. I just want to be clear that that means that the obligations land on us, statutory obligations.
No problem.
Absolutely right.
It's the whole issue of public notice in newspapers has gotten beyond any ability to know. I mean, do we have newspapers left that really would count as, papers with statewide presence? I don't know anymore. Sad as that may be to say. But beyond that, I have nothing more to say. Anybody have any questions, comments? Then, the next item on the agenda is a motion to go into executive session to wit. A motion to approve minutes of the executive session held on February 11th, 2025 pursuant to RI General Law Section 45, 46, 5, A2 and 4. B, to take up In re Michael Colasante, complaint number 2023-10 pursuant to RI General Law Section 42, 46, 5, A2 and 4. And then a motion to return to open session. Is there such a motion? Motion by Commissioner Ritchie, seconded by Commissioner Rabideau. Commissioner Susie,
Aye.
Commissioner Strauss, Commissioner Browner, Commissioner Harrison,
Abstain.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Going to executive session.